Yes. We record it to YouTube, and then the actual live event is through a service called Zoom. So YouTube link from it on. Not technically.
Right. Also, the people on YouTube couldn't go.
Yeah, but nobody goes to our page for the live stream. They have a link that takes the reference. They're posted afterwards.
Give us the count.
Yeah, and so we're not on camera, so I can visually signal you from behind you once we're good.
So like an on-off button, we start or you start?
We're going to start it for you. All you'll have to do is once we give you the okay, like once it hits noon, you can just start, and all you have to do is click through the PowerPoint. And then when you're done, we'll end everything. So
I'll tell you when to hit the first slide.
All right.
Where's our timer for noon? Okay.
thank you. This way.
As soon as we hit noon, I'm going to start.
Yeah, and I'm actually, what is it? 2 minutes. I'll wait till 59, and then I'll actually start the meeting so that people can get connected. So at that point, we're technically live, but
Okay.
we'll just wait until we get to the actual start. Yeah. 663-854-670. I'm going to start it up so people can get connected. So we'll go silent, but you can actually start when the clock hits 12.
Good afternoon and welcome to WG University, Weber Gallagher's series of educational programs. This is our first presentation in our insurance webinar series. I am Jane Kelsey and I am presenting today with Ken Sharperson. We're both attorneys in the insurance practice and reinsurance practice group with Weber Gallagher. If you would like to view this webinar again, share it with others, or see other WG University programs, please visit the Weber Gallagher website at www.webergallagherwglaw.com, and you will find copies of this presentation and others under the WG University page. Also, if you have questions about our presentation, you can either contact the firm at questions@wglaw.com, or at the end of the program, we will direct you to a slide with Ken and my direct email address, and we will be happy to respond to your questions after the presentation. So today's presentation is nuts and bolts of claims-made policies. And when we talk about claims-made policies, it's important to have an understanding that no two claims-made policies are alike. And while we can't possibly talk about all of the intricacies and nuances of claims-made policies in our short 30 to 40-minute presentation today, what we would like to do today is offer an understanding of some key components of these policies in this program, whether you are an insurer or a policyholder, as these components are going to determine coverage. We will plan to provide you with an overview of some of these key concepts today. We plan to cover the key distinctions between claims-made versus occurrence policies. We will cover what is a pure claims-made versus a claims-made and reported policy. We're going to cover one of the defining features of a claims-made policy, which is retroactive coverage. We're going to talk about what a wrongful act is and what constitutes a claim. For instance, can a claim consist of a non-monetary demand or a threat, an administrative or an EEOC filing, and what effect do related claims have on the scope of coverage? Finally, we're going to talk about the notice and reporting requirements of a claim and the application of the notice and prejudice rule in a claims-made policy context. So let's get started with slide number 1 and talk about the initial distinction between an occurrence policy and a claims-made policy. So initially, an occurrence policy and occurrence coverage protects someone from any covered incident that occurs during the policy period, regardless of when a claim is filed. So most third-party liability policies are occurrence-based. And what's important to understand in occurrence-based policies is that in order for a loss to be covered under such a policy, the damage at issue must occur during the policy period. And in most instances, it doesn't matter when the claim is actually asserted, as long as the damage takes place during the policy period. And so we see a lot of these occurrence policies, for instance, in medical malpractice professional liability policies. So, for example, if a physician has a policy with a policy period that runs from January 1, 2012 to January 1, 2013, for instance, and he is sued subsequently in a medical malpractice action that took place several years later in March of 2015, for an alleged act of malpractice that took place during that previous policy period in year 2012, setting aside any of statute of limitation issues that might arise, he would be covered under that occurrence policy, even though the claim was not asserted until year 2015 after the policy had run, because this occurrence policy protects you from covered incidents that occur during the policy period, regardless of when the claim is filed. So now let's go to the next slide and contrast that with a claims-made policy. Under claims-made coverage, a policy providing coverage under a claims-made policy is triggered when a claim is made against the insured during the policy period, regardless of when the wrongful act that gives rise to the claim takes place. So under a claims-made policy, the insured is required to file the claim during the policy period or during what's called the extended reporting period, or ERP, if applicable. Now, an extended reporting period simply is an additional clause typically that's written into a policy that includes a designated time period after the policy has expired, typically 30 or 60 days, during which a claim may be made and coverage is triggered as if the claim had been made during the coverage period. This is sometimes called tail coverage. Now, one of the benefits of a claims-made policy is that it is not necessary to determine when the particular event that gives rise to the claim occurs, because it is actually the making of the claim itself that triggers the coverage, and not the occurrence of the damage that gives rise to the claim. And another benefit is that insurers can limit the time during which they will be subject to claims being made under a particular policy to a certain finite period. So an insurer's exposure ends at a fixed point, and it's usually that policy termination date, versus under an occurrence policy where the insurers can be subject to claims sometimes many years or even decades after a policy expires. Let's go to the next slide, please. Now, one of the most widely used forms, and the most widely used form under a claims-made policy is the claims-made and reported policy. So a claims-made and reported form requires not only the claim must be made during the policy or the extended reporting period, the ERP, but it must also be reported during the same period. And this means that the insured has a designated time frame within which claims can be filed, but it is also the obligation of the insured to report the claim or a potential circumstance that could lead to a claim to the insurer within the policy period or the extended reporting period. And typically, the keywords to look for on a policy declaration page in order to determine if you have a claims made and reported policy, it's usually in a box notice, and the words that you want to look for are something like, this policy covers only those claims that are first made and reported against the insured during the policy period, or ERP, extended reporting period. And there is also designated language within the policy that will state similar language so that you know that this is a claims made and reported policy. Now let's contrast this with the next slide, slide number 4, which is a pure claims made form, and these are less commonly seen. Now, in a pure claims made form, this requires that the claim be made during the policy period or the extended policy period. And the major difference between a pure claims made policy and a claims made and reported form is that under a pure claims made policy, you will typically see language that the insured is required to report the claim as soon as possible, or you will also see language like, quote, as soon as practicable, close quote. And that means that the report of the claim may happen after the policy's expiration. Now, Ken and I have seen cases, and this as soon as possible or as soon as practicable language has been the subject of much litigation, and as you can imagine, time constraints do not permit us to go into the kinds of cases and type of litigation that are factual driven in order to determine what is as soon as possible or as soon as practicable. But Ken will be discussing that in the context of an interesting case that went up to the New Jersey Supreme Court later on, the Templo Fuente case, and we'll be discussing that later on in the context of the notice-prejudice rule. But for now, let's go on to our next slide, because I want to discuss the concept of retroactive coverage. So what is retroactive coverage? Retroactive coverage is provided in claims-made policies for acts or omissions that took place prior to the effective date of the policy, as long as they are first asserted against the insured and reported to the insurance company during the policy period. So this is a defining feature of a claims-made policy, in that it does provide for coverage for acts or omissions that take place prior to the effective date of the policy, so long as they are first asserted against the insured and reported to the insurance company during the policy period. But there's an important but here, and let's go to the next slide. But claims-made policies will typically exclude retroactive coverage for a claim if the insured knew or could have reasonably foreseen prior to the effective date of the policy that the act or omission could have given rise to a claim. So, for instance, if you have an attorney error which leads to the dismissal of a client's case, and it's based upon a negligent act or omission, that is a scenario where an insured knew or should have known that scenario could reasonably be likely to give rise to a claim. In that scenario, the retroactive coverage would be excluded, because the insured would either have known of the act or omission or reasonably could have foreseen that the act or omission might have been the basis of a claim, and in that scenario there would be no retroactive coverage for that type of claim. Okay, next slide. So retroactive coverage, the purpose of retroactive coverage, number one, is to eliminate coverage for situations or incidents known to insureds that have the potential to give rise to claims in the future, and obviously to preclude coverage for stale claims that arise from events far in the past, even if such events are unknown to the insured in the former case. So that brings us to what is a wrongful act? A very important component of a claims-made policy. The wrongful act component serves as the claim trigger under a claims-made policy, and it's generally defined as any actual or alleged error, omission, or negligence committed by the named insured. And in simple terms, the wrongful act is what the insured has done to get himself or herself sued. The wrongful act doesn't have to happen during the policy term, but it must happen after the retroactive date, the date when the policy begins. So it is important to read and understand your definition of wrongful act under the specific type of policy that you have, because the failure to read and understand the definition of wrongful act has and can result in policy coverage exclusions. Now, let's go to the next slide. So let's look at how some of the policy definition exclusions of wrongful act can differ based upon the types of policies that you have. For instance, the most common definition of wrongful act in an employment practices policy can include sexual harassment, discrimination, or wrongful termination. Contrasted with the definition of wrongful act in a D&O director and officers policy, which can be, quote, any actual or alleged breach of duty, misstatement, or misleading statements committed by the insured. So, again, a major basis of exclusion for coverage is if the acts for which coverage is sought do not fall within the coverage definition of wrongful act. And let me give you an interesting example of a 2016 appellate division case that came out of Maryland by the name of Feldman versus Fidelity and Deposit Company. The Westlaw site is 2016 Westlaw 885041. This turned on the definition of wrongful act. In that case, there was an insurer who issued a D&O policy to a bank, and one of the directors of the bank was being investigated by a regulatory agency regarding certain regulatory transactions he had been involved with as a member of an unrelated LLC corporation. He later settled the claim with no admission of liability, but the insured bank's D&O carrier denied his claim for reimbursement as the claim did not allege a wrongful act, because under the policy definition, the claim was not made against an individual solely in his capacity as a director and officer of the insured bank. Here, he was being investigated as a member of an unrelated LLC. So the policy exclusion turned upon specifically the definition of wrongful act in that particular case. And that's why the reading and understanding of these terms and their definitions become critically important in terms of an understanding of coverage in these types of policies. Next slide. So now that brings us to what constitutes a claim. And before an insured can report a claim, it's important, critically important, to understand what constitutes a claim. We've seen in our cases that because of stringent reporting requirements and claims-made policies, not knowing when or what to do when a claim arises can spell disaster to an insured. And it's ultimately the insured's responsibility to report a claim or a potential claim under circumstances that can give rise to a claim. And, you know, with claims-made coverage, it's essential that an insured promptly recognizes when a claim is being made, and in a lot of situations, it is not as simple as getting served with a lawsuit. And as will be discussed, it is not straightforward. And I'm now going to turn the program over to my fellow panelist, Ken Sharperson, to take us through how a claim has been defined in some very interesting scenarios involving non-monetary demands, subpoenas, and administrative filings. So Ken, let's talk about the first category of cases where non-monetary demands have risen to the level of claims.
Yeah, thank you, Jane. As Jane mentioned, one of the significant disputed areas with respect to claims-made policies is what actually constitutes a claim. And for the most part, if an insured receives a lawsuit or a complaint, they would recognize that that's a claim against them that should probably be reported to their insurance company. However, there are various scenarios where a non-suit demand may be considered a claim, and that's what we're going to talk about in this next slide. The first category we're going to talk about is a non-monetary demand or threat. And the SM Electric Company case was a case in New Jersey which held that a pre-suit demand letter would constitute a claim. And the facts of that case are as follows. The plaintiff sent defendant a letter in 2008 seeking $15 million for some additional work that was performed on a construction project. No notice was provided to the carrier of that letter in this case. 2 years later, in 2010, the plaintiff actually sued the defendant, and at that point, when the lawsuit was received, the defendant gave notice of this action to its insurer. The insurer denied coverage on the basis that the 2008 letter was deemed a claim under the policy and advised the insured that late notice barred the claim. In that case, the policy defined a claim as a demand for money arising out of professional services, which is why the court actually agreed with the insurer and upheld the disclaimer. And the key takeaway from this case is that a lot of times many insureds don't realize that a pre-litigation notice can actually arise to a claim. So anytime there's a potential or anything that smells like a claim, it should be actually reported and notice should be provided to the insurance company.
Yeah, we actually, and in fact, in our office, we've actually had a couple of recent cases in an employment HR context in which a threat of a suit was reported to an HR manager, Ken, and in fact, or a request for harassment or discrimination action was taken, and the HR manager had not notified the insurance company of those threats of suit or requests for action on harassment and discrimination claims. And it later turned into a lawsuit, and the coverage was subsequently barred because those initial threats of suit or requests for action later were deemed to be first made claims and constituted claims under the policy. So there's another situation where those non-monetary threats or requests for action can very likely constitute a claim based upon how your policy is defined.
That's correct.
Okay, so why don't we talk about the next category of subpoenas?
Yeah, so many government investigations begin with the issuance of a subpoena, and oftentimes coverage is disclaimed if there's no formal investigation that is eventually commenced by a government agency. However, courts recently began trending towards providing coverage simply upon receipt of a subpoena. And for example, in the Jimco Partners v. Executive Risk Indemnity Incorporated case, which is a Superior Court case here out of New Jersey, the court actually did determine that a subpoena seeking documents was a claim. And that case went as follows. The plaintiff was served with a subpoena from two government agencies and also what's called a grand jury subpoena. The plaintiff provided timely notice, and the insurer still denied coverage on the basis that the subpoenas were not claims as the policy defined them. The court actually rejected the insurer's position because they found that the grand jury subpoena met the portion of the definition of claim which was defined as relating to a criminal proceeding in a court of law. And they also found that the government agency subpoenas, one was from the SEC, were actually administrative or regulatory proceedings. So based on the definitions of claim in that particular policy, the court did find that those subpoenas were claims. So as you can see, the cases that find subpoenas or claims often turn on the policy's specific language, as the Jimco case demonstrates. And finally, our next line of cases are what we call administrative or EEOC filing cases. And Jane gave a brief preview of a case that we handle here in this firm, and I'll provide some further detail later. But essentially, an administrative filing is typically going to be deemed a claim under a claims-made policy. And again, I'll go into more detail on this later in the presentation. Next, what I'm going to discuss is what was called the interrelated or interrelated claims. And essentially what these are losses that stem from the same or related acts, and they're considered single claims under a policy. Likewise, multiple claims with a common nexus or that are logically connected can also be deemed the same claim. And the reason that interrelated claims that this is important is because there's typically an exclusion in policies which will exclude claims that are brought in a subsequent policy period if there was a related or prior pending claim that related to that same claim. For example, in the J. Graham Saruki case versus Federal Insurance, which is a case out of Connecticut, that court found sort of the opposite when it came to the related claim exclusion, was that it didn't apply because the claims that were the genesis of these suits were sufficiently distinct such that that exclusion would not apply. It's a very complex fact pattern, but I'm going to go through the facts of this case. In this case, the plaintiff defaulted on a promissory note which was issued in 1999 by a creditor. The creditor sued in 2002, and as a result of that suit, the parties ended up entering into a settlement agreement such that that the loan would not be then have to be payable until 2012. The plaintiff did not provide notice of this 2002 suit to its insurance carrier. Later in 2010, the plaintiff actually defaulted on this settlement agreement that was entered into, and then the creditor sued the plaintiff again. Again, the plaintiff did not, in this case, provide notice to the insured. Approximately 2 years later, the plaintiff did provide notice, and the insured denied coverage on the basis that the 2010 lawsuit was related to the 2002 lawsuit, and such was barred under the related claim exclusion. The court actually disagreed with the insurance company here. They found that the exclusion did not apply because each suit, the 2002 suit and the 2010 suit, involved the breach of different contracts, and thus the claim did not arise from the same or substantially similar facts or circumstances. The court, however, in this case, did agree that that coverage would be barred under late notice because there was the 2-year gap between the time the 2010 litigation was reported to the insurance carrier. So this is a situation where, because the claims were not sufficiently related, that the court held that exclusion did not apply, although it did bar coverage because of late notice. Now, there are situations where, under the interrelated and related claims space, where you'll have the same parties, similar causes of action, but you have a subsequent suit.
Next slide.
But you have a subsequent suit. And this firm handled a case called Willemborough School District versus National Union. And essentially that was a case where the Willemborough School District was sued by an HR manager who was asserting gender discrimination and retaliation. And what she did was she filed an EEOC proceeding and with these allegations. She later withdrew the EEOC proceeding and filed an action in the Superior Court of New Jersey in a subsequent policy period. When she filed the action in the Law Division in New Jersey, the Willemborough School District reported the claim to National Union. National Union took the position that the claim was not first made during the applicable policy period, and they also alleged that the claim was rather first made a year before the policy period, when the HR manager actually filed the EEOC complaint with the New Jersey Division of Civil Rights. Discovery ensued in this coverage dispute, and it was established that there were identical facts and identical causes of action that were filed in the Law Division that were very similar to those in the EEOC proceeding. Willemborough, in an effort to get coverage, argued that the Law Division action actually constituted a different claim than the prior EEOC complaint, as it was premised upon additional and different causes of action. However, in granting summary judgment in favor of National Union, the court actually ruled that the Law Division claim fell under the exclusion which precluded claims that were derived from the same or essentially the same facts as those in a prior unreported proceeding. And this case is really consistent with many of the courts in our country who ruled that the initiation of EEOC proceedings and not a subsequent court filing control in determining when a claim is first made within the context of the employment practice liability claims. I don't know if Jane had a...
Yeah, I think that's important in that it's considered a continuum. That's considered the first made claim, and the fact that you may add new parties or new causes of action subsequently, so long as the factual underpinnings are identical, is really something that the court will consider significant and dispositive in determining when the claim was first made. And in the Willemborough case, the fact that the factual underpinnings of the EEOC complaint were virtually identical to this HR manager's subsequently filed law division action, I think was dispositive in establishing when the claim was first made, and with the determination that since the HR manager had not, and since Willemborough had not given notice to National Union at the time when the EEOC matter was first filed, that coverage was barred, and I think that was ultimately dispositive in finding that no coverage was applicable in that case.
Right. And now, as we move forward, the next issue we're going to talk about is what's known as the notice-prejudice rule. And essentially, the notice-prejudice rule provides that an insurer may not deny a claim on grounds of late notice without demonstrating prejudice. And that's typically the rule in New Jersey. There is an exception, however, where under a claims-made policy, failure to provide timely notice will bar coverage even in the absence of prejudice. And this arose in the Templo Fuente case, which was again a case that Weber Gallagher handled, that went all the way up to the Supreme Court. And as you probably recall from the Willemborough matter we just discussed, when notice is provided outside of the claims-made policy period, it's fatal to coverage. But in this Templo case, a novel issue was raised because notice was actually provided during the policy period, but coverage was still denied. And in Templo, the policy contained a requirement that the policyholder provide notice as soon as practicable. Templo actually, after the lawsuit was filed, did not provide notice to the insurance company until 6 months after suit without any explanation as to the late notice. And the Supreme Court held that the term as soon as practicable is unambiguous, and a 6-month delay was not as soon as practicable. And so the takeaway from Templo is that courts strictly construe notice provisions, and that notice must be a priority for the insured. You should not wait once you receive any suit or any potential circumstance of a suit to wait to provide notice. Otherwise, the insured risks losing coverage. And likewise, under a claims made and reported policy, the court has held that the notice prejudice rule does not apply. And I was recently, almost last week or a month ago, the food market merchandising case versus Scottsdale Indemnity Company case came down. And in that case, the Eighth Circuit affirmed summary judgment in favor of the insurer, holding that a conditioned precedent of timely notice, and in this case the policy again was as soon as practicable, was not met where notice of the lawsuit was provided 7 months late. In that case, again, to try to obtain coverage, the insurer argued that prejudice must be shown by the insurance company, but the court disagreed, and essentially the court held that notice was a conditioned precedent to coverage under a claims-made policy, and therefore prejudice does not have to be shown by the insurer. And so we've gone, as you can see, we've gone over several issues as they relate to claims-made policies. We hope that you take away something from this presentation. But the biggest thing you can probably tell from this is that insurance coverage law is constantly evolving. Insurers and insureds alike must be aware of the evolution of case law, because the changes can have direct ramifications on both insurers and insurers when it relates to coverage disputes.
And even though this was a very brief overview, we've hoped that you've taken away some of the key concepts of claims-made policies and understand that no two policies are alike, that it is important to know and understand whether you're dealing with a pure claims-made versus a claims-made and reported policy, as it will have significant implications for your reporting requirements. And just be sure to carefully review and understand your policy definitions, your definitions of wrongful act, your definitions of claim. And for insurers, you'll want to consider whether successive claims or suits may give rise to a related claims exclusion, or whether you are truly dealing with a new or different claim based upon new or different facts. So Ken and I want to thank you for attending our first insurance webinar, Nuts and Bolts of Claims Made Policies. Our next program in the insurance webinar series will be on August 30th, and we have a very interesting topic on how to obtain optimal results of insurance arbitration disputes. There will be more information on this and other insurance webinars in future Weber Gallagher emails. You can please feel free to email questions directly to Ken or I at the email addresses provided on this final slide. And we thank you for joining us today, and please have a safe and happy 4th of July weekend.